Equal employment opportunity, or EEO, is defined as the fair and unbiased treatment of all individuals in any aspect of employment, such as hiring, promotion, and training. The Equal Employment Opportunity Commission, or EEOC, was formed in 1965. The purpose of this federal agency is to administer and enforce civil rights against workplace discrimination based on an individual's race, children, national origin, religion, sex, age, disability, sexual orientation, gender identity, genetic information, and retaliations for reporting, participating in, and/or opposing a discriminatory practice. The topics covered in this presentation include a brief history, federal laws and regulations, discriminatory issues, and managing discriminatory practices. EEO has slowly become a national priority in the United States, and even though the U.S. has come a long way regarding public attitudes about discrimination, there are still issues that plague the country relating to discriminatory practices and treatment. The three main factors that have influenced the EEO legislation are changing attitudes about employment discrimination, published reports highlighting the economic issues and injustices experienced by the minority workers, and a growing body of discrimination laws and regulations at different levels of the government that legislators agree should be standardized. Although many legislative measures were developed early on in order to resolve inequalities in workplace environments, they actually did very little to correct employment discrimination. The laws did not specify what discriminatory practices needed corrections, and employers were not required to conform to EEO legislation. Major federal EEO laws have been established to prevent discrimination against protected classes of individuals. These classes include individuals of a minority race, women, older age groups, and those with disabilities. A few of these laws are the Equal Pay Act, Americans with Disabilities Act, Civil Rights Act, Equal Employment Opportunity Act, Pregnancy Discrimination Act, Uniform Services Employment and Reemployment Rights Act, and the Don't Ask, Don't Tell Repeal Act. Executive orders and some federal laws are used specifically to provide equal employment opportunity to individuals employed through government contractors. The three laws and executive orders mentioned from our textbook are the Vocational Rehabilitation Act, Executive Order 11246, and the Don't Ask, Don't Tell Repeal Act. EEO issues have been publicized and reported for years. However, in more recent years, issues such as sexual harassment, sexual orientation, immigration discrimination, physical appearances, and other discriminatory acts have become more publicized and reported more often. Sexual harassment in the workplace and beyond has become a huge debate. Sexual harassment acts can be classified as unwanted physical contact, sexual comments, and even nonverbal gestures such as staring at an individual's body in a sexually attracted way. In recent years, the LGBTQ community has become more adamant about equal rights and fair treatment. Discrimination against their sexual orientation and identity takes place in working environments and in public settings. Examples of LGBTQ-related claims that EEO views as unlawful sex discrimination include failing to hire an applicant because he or she is a transgender man or woman, denying an employee a promotion because of sexual orientation or gender identity, harassing an employee because of his or her sexual orientation, such as by making derogatory or sexually oriented comments, discriminating against or harassing an employee because of his or her gender identity. Immigration has become a national priority in the United States. Employers must comply with the U.S. Department of Justice's Handbook for Employers, which lists 5 actions employers must do in order to act in accordance with the law. Have employees fill out their part of Form I-9, check documents establishing an employee's identity and eligibility to work, complete the employer section of Form I-9, retain Form I-9 for at least 3 years, present Form I-9 for inspection to an Immigration and Naturalization Service officer or to a Department of Labor officer upon request. Many employers also use E-Verify, a system that provides an automatic link to federal eligibility of workers and the validity of their Social Security numbers. Employers who violate the discrimination provisions of the IRCA will be ordered to cease the discriminatory practice and may be ordered to hire the individuals discriminated against and to pay a fine for each person. There are so many other discrimination issues coming to light in today's society and businesses. Weight discrimination is nearly as common as racial discrimination and is mostly directed at women. However, there are no federal laws to prohibit this type of discrimination, even though the EEOC has stated that morbid obesity is a protected disability under the ADA. Individuals are also being discriminated against based on their attractiveness. The modeling industry and news stations are the main culprits for this type of discrimination, but they're not the only ones. Other businesses have turned away qualified applicants on the grounds that they weren't attractive. Once again, however, there are no laws to protect these individuals who have been discriminated against for being unattractive. Being a caregiver does not necessarily mean the individual is protected by law against discrimination. The law comes into play when the caregiver is being discriminated against for characteristics that fall under equal opportunity laws, such as sex, race, age, caregivers with young children, or caregivers with disabled children, along with many others. The uniform guidelines apply to employee selection procedures in the areas of hiring, retention, promotion, transfer, demotion, dismissal, and referral. It is intended to help employers, labor organizations, employment agencies, and licensing boards comply with the requirements for federal laws prohibiting employment discrimination. The EEOC is responsible for ensuring that covered employers comply with EEO legislation and accomplishes this goal by issuing employment guidelines and monitoring the company practices and protecting workers' rights through investigation and prosecution. The individual who claims to have been discriminated against can file a charge form with the EEOC within 180 days of the alleged unlawful practice occurring. Affirmative action occurs when employers take proactive steps to reverse past discrimination. These employers encourage employment diversity and offers training classes to further this as an acceptable action. The EEOC was originally created to guarantee fair practices in the workplace environment regardless of gender, race, or age. Employers should know, understand, and conduct fair employment practices that conform to the laws reviewed in this presentation. Employment discrimination takes the form of discrimination by race, sex, sexual orientation or identity, age, religion, and disability. Sexual harassment and weight have also become a significant issue for employees. The uniform guidelines were put in place to aid employers in the compliance of federal laws that bar employment discrimination. Employees or applicants who believe that they have been discriminated against can file a complaint with the EEOC, and if the compromise is not met, the EEOC can elect to sue the employer in federal court.